the law prescribes certain parameters through which land is categorized as family land. These parameters are not hard to understand, and I'm going to run through them one by one for you. Now, the first legal parameter for family land is that land where the family ordinarily resides. So if there is any place on which the ordinary residence of the family is situated, then that place or that land is family land within the meaning of the law. Ordinary residence of the family is also defined by the law, and the law defines it as that place where a family lives with a degree of continuity. And continuity within the meaning of the law excludes those episodes of temporary absence. So if you ordinarily live in a place as a home or as a residence of the family, it is immaterial that sometimes you are absent from that place. So for example, if you have a home in the city and a home in the village, it does not matter that you live in one home longer than the other, as long as both serve as homes for the family. Where they are located will be family land within the meaning of the law. Also, if the family lives in a particular place with an intention of making that place their home for an indefinite period of time, that land becomes family land, provided the land belongs to one of the spouses. Of course, if you are renting out a place, even if you live there for 20 years, it will never qualify as family land because it does not belong. So when I'm talking about family land, I'm talking about land which is owned by one of the parties to the family. So you should not go around and, having lived about 5-10 years in a particular place, as a family, but when the place is rented, you turn around and say this is our ordinary residence as a family, or this is family land. No. The concept of family land has an element of ownership. So if you both do not own the place, it cannot be family land. The second parameter is related to the first parameter that I have just run you through, and this is a place where the family ordinarily resides and from which the family derives their sustenance. The two seem similar, but they are internally different, and the angle of difference is brought in by the aspect of deriving sustenance. The law goes ahead to specifically define what derivation of sustenance is, and the first is land where the family farms. So if there is any land belonging to one of the spouses, and on that land the family has farming activities, that land is family land within the meaning of the law. There is no shortcut. So as long as the family have farming activities on any particular land belonging to one of the spouses, then that land is family land. Then, if there is any land which the family regards or treats as their principal source of livelihood, then that land is family land. If the family treats a particular land as their principal source of livelihood, that land is family land. So if you live in a place and at the same time your means of survival are derived from that place, then if that place or if that land belongs to one of you as family, that becomes family land. A clear example is where a husband or a wife own a commercial property, and on that commercial property, there happens to be a shop belonging to one of the spouses, and from the shop, the income is used, to sustain the family. So a combination of ordinary residence on that place and the derivation of sustenance for the family from the shop that is run on that same building makes the building family land. So as long as a family regards any piece of land as their principal source of livelihood, that land is family land within the meaning of the law. Lastly, where a family freely and voluntarily agree that a particular land is going to be employed or is going to be utilized as the source of income for food, that land becomes family land within the meaning of the law. And it becomes family land because by that agreement that a particular property or particular land is going to be the source of income for their food, it becomes land from which they derive their sustenance. So if there is such agreement, and if such agreement is free and voluntary, then within the meaning of the law, the land to which that agreement is made becomes family land, and it must be treated as family land within the meaning of the law. The third parameter for family land is what I have just explained while explaining the concept of derivation of sustenance for the family, and that is land where a family agree is to be treated as family land. So if there is any agreement that a particular land is going to be family land, it is family land, and it does not matter what is being done on that land. So in the previous statement, I was telling about land where family agree that it is the source of income for their food. Here, the difference is that as long as family agree that particular land is family land, it doesn't even matter whether or not there is anything the family is deriving from that land. So as long as there is an agreement that that land is family land, then it is family land within the meaning of the law. Now, you will ask me what form that agreement must take. The law does not prescribe any particular form which that agreement must take, but it is better if such agreement is in writing. Lastly, the fourth parameter for determining whether land is family land or not is where any land is customarily or culturally, treated or regarded as family land. So if any piece of land or any land is culturally or customarily regarded as family land, that is family land. A case in example is the family burial sites. For the communities which have common burial sites or family burial sites, that land where burial sites are situated is family land within the meaning of the law. And the list does not end, so you should be able to interrogate your particular customs or your particular cultures, and as long as any piece of land is by your culture or by your custom regarded as family land, then that land is family land within the meaning of the law. Of course, under the law, if you seek to rely on a custom, you should know that it will be your duty, to prove that the custom actually exists. The bottom line is, as long as culture or as long as custom regards any land as family land, then that land is family land also within the meaning of the law. The long and short of my submission on this issue is that before any land is categorized as family land, you should be able to carry your own facts regarding that land to your lawyer and then seek advice. It's that legal profession that will be able to weigh the circumstances that you have taken to him and make a reasoned determination on whether that land is family land or not within the meaning of the law, and then that person will render advice to you. So before you run there, you should be confident that that person is actually well placed to give you the advice that you seek. That said, I thank you for listening to me, and do not forget to subscribe to the channel, and be ready for the next episode where I will be teaching you about dealings with family land, and specifically I'll be teaching you about the requirement for spousal consent in all dealings with family land. I will be teaching you the do's and don'ts when dealing with family land, and by teaching you that, I hope that I will be contributing to the alleviation of family conflicts touching family land. So subscribe to the channel so that you are able to follow me as I teach you about this very disturbing aspect of our social life. Thank you very much for listening to me, and may God bless you.